Hi, it's Anne-Marie from Charmed Life Therapy. Today feels like a day for buckling up and strapping in. I guess there's a lot going on, even just from the video I made yesterday. How I kind of specified in that would Lyman come back really, really fast, and he did. And of course, he came down on Lively's side, it would seem, into Van Zan's side, because of course Van Zan has nothing to do with Blake Lively, not colluding at all in this matter. Um, but yeah, it came down fast on their side. But when you look to the people that are in the know, like Little Girl Lawyer, is it, and Not Actually Golden, and people like that, they're saying, calm down, basically, cool your jets. There's almost that feeling that Wayfarer and Kevin and all of these people kind of expected that. And in a way, they had to do it in order to just prove the point that Van Zan were not saying they were happy to talk about anything prior, basically, to the subpoena going out, no discussions that took place, who set it in motion, any of that. So they were having difficulty, it would seem, Wayfarer, establishing what Van Zan were willing to talk about ahead of the deposition that's due to go ahead on the 30th. So they felt they had to do this thing, basically, that they were probably going to get wrapped on the knuckles for, but it established some precedent, basically. So even though they have to pay attorney's fees for Van Zan for that, it would seem that it had to be done, really. And that must be a frustration for Wayfarer, that sense of we have to be seen to be looking a bit stupid in order to just get done what we need to have done. But I guess lawyers are used to this kind of thing, so it was no point getting upset about it or jumping on the internet, really, and saying, oh, we've been beaten again and all of this. That just really wasn't very helpful. And at the same time, we've got Ryan, who literally I just feel like shouldn't be given a stage or a platform at this point, because he's just shooting himself in the foot over and over again. And in fact, I feel like there's a sense of he's enjoying all of this at this point. He's going about the country now, doing on stage or whatever, talking about the John Candy documentary. So he's reliving the story of how he got Bill Murray on board over and over again. And it seems to be changing all the time. And it's possibly changing all the time based on who's reporting it as well. I think the original story was along the lines of he couldn't get hold of Bill Murray, and then eventually, when he did, his kid walked in the middle of the night. The youngest toddler walked in, and I think the original story was something along the lines of, say this to Bill Murray, the kid said that, and then it's like, well, now you can't turn down the child. The original story seemed to be something along those lines, and now it's like his whole children film something in order to present to Bill Murray. Who knows what is right? Who knows what's accurate? But either way, we do know that Ryan Reynolds feels quite happy to use his children in order to get what he wants. He's got no compunction about that whatsoever. Make of that what you will. But now he's also happily saying on stage that when Bill Murray finally did call him and he was due to go into some red carpet event somewhere or other, and Blake says we have to go in, he happily told her to fuck off. It's Bill Murray. And of course, the crowd all laughs at this. And it's like, but Ryan Reynolds must love all of this, because literally, like Ryan Reynolds' life, everything he does is about how controversial can I be, and people will laugh at it anyway. And I will know I'm saying something controversial, and I will enjoy that laughter, and I will enjoy that I'm pulling the wool over people, and I will enjoy that I'm saying and doing controversial things, and people will have the reaction to it that I want them to have. This is what's happening. It's like literally Ryan Reynolds enforcing his own narcissism, reinforcing it, bolstering it. He doesn't give a damn about Blake Lively's feelings. And this could well be the story of their marriage, literally. And I hark back to that thing I said about that dance montage and why I think Blake Lively was so triggered by it all. Because remember, my perspective all along has been when the face to face like this, doing that dance montage, Justin just wanted to look into her eyes. There was no need for dialogue in that scene. It was a montage scene. Didn't want any dialogue. She insisted on talking because she couldn't handle direct eye-to-eye intimacy, basically, because it was not what she was used to. She's used to talking and swearing at each other and bantering and putting each other down and all the rest of it. That is what intimacy looks like to Blake Lively. That's what she's been trained to accept as intimacy, you know, and possibly she didn't see genuine intimacy between her parents. We don't know what intimacy looked like between them, but it certainly wasn't stillness and quietness and just gut instincts and intuition and instantly being on a wavelength with somebody. It's nothing to do with that. That's why she was so uncomfortable and couldn't stop herself talking, which is actually literally what has got her into a lot of trouble, hasn't it? In terms of she tried to use that as the SH ammunition, if you like. So let's look at the paperwork. What I find almost more interesting than Wayfarer's wanting a judgment on the pleadings, basically. I mean, obviously, we all get, ooh, exciting, but of course, it's also tempered by the fact we kind of feel like Lyman just doesn't really matter what you say to Lyman at this point in time. But what I find kind of more interesting is the fact of how desperate Blake is to get in first with the deposition questioning of this guy that's a Sony executive. So let's bring that up first, because that's I haven't read that. I haven't had to go through and highlight it all. Let's just kind of read it fresh and we'll take a look at that, because possibly some of you out there are fed up of hearing about the pleadings thing, but I do feel like I have to go through it anyway. But let me just share my screen and we'll bring up this first. Right, I seem to be sharing. So yes, I'm on the right thing. So this is a letter from Manat. So, dear Judge Lyman, plaintiff Blake Lively, reluctantly, respectfully, and urgently requests that the court enter an order holding that Ms. Lively has the right to begin the questioning of Mr. Josh Greenstein at his deposition currently set for Tuesday, September 30th. It's a big date, September 30th. And to Mr. Greenstein, it could be Greenstein, my apologies for which is correct. Deposition will commence sharply at 8 a.m. So she's desperate for it to commence sharply at 8 a.m. Pacific Standard Time in order to accommodate the deponent's request that the deposition must end by 4:30 p.m. PST. And Ms. Lively shall have 4 hours to question Mr. Greenstein first, including no more than 30 minutes of breaks if requested by the court reporter, videographer, or deponent. Neither the deponent nor his counsel nor Ms. Lively oppose an 8 a.m. start time or the proposals regarding examination time or breaks, but one of the defendants' many attorneys, as if they haven't got many attorneys, has refused to agree to start the deposition an hour before scheduled due to an unspecified conflict. I imagine this is Brian. Do you think this is Brian? Without an 8 a.m. start time, there is a significant, perhaps inevitable risk that one or both of the noticing parties will have to leave Mr. Greenstein's deposition open to complete on another day. An 8 a.m. start time would provide plaintiff's counsel with a 4-hour window to achieve the allotted 3.5 hours of on-the-record testimony, which would be followed by a 30-minute lunch and a 4-hour window of time during which the defendant's counsel can question the witness for their 3.5 hours of testimony. I just find it really interesting that she's paranoid about getting in first. I mean, I know like it'll be an objection to her if she misses out on time, but I think it's more a case of maybe it's the standard practice for plaintiffs to get to question first. I don't know, but I think there's something about this guy being a Sony executive, or I don't know if he works for Sony anymore, but he certainly was at the time. So it's like, why is it so important to get in first? Is it like to condition him? It's interesting, isn't it? So rather than accept the proposal agreed upon by my Lively, Ms. Lively, I presume, and the deponent, the Wayfarer defendants refused to find a reasonable middle ground, Exhibit A, They first agreed that Ms. Lively could begin questioning on the condition that it be limited to a 3-hour window from 9 a.m. to 12 p.m., notwithstanding an agreement that each party received 3.5 hours of on-the-record testimony pursuant to the federal rules. The Wayfarer defendants then reneged on that agreement after Ms. Lively issued an updated notice of subpoena reflecting an 8 a.m. start time in response to the following request from counsel for the deponent to begin at that time. But basically, she'd no business just issuing that to them, agreeing it with the deponent, and then just issuing it to Wayfarer. There needed to be a conversation that all of them were on board before anybody agreed anything. So we strongly urge counsel to make this schedule work with an 8 a.m. start time. The parties are well represented by numerous law firms with big teams of talented lawyers and should be able to accommodate an 8 a.m. 4:30 p.m. deposition schedule for this non-party individual. I feel sure this is Brian that can't be there, and that's why she's making such an argument about it, I would imagine. Undersigned counsel tried earnestly and repeatedly to avoid seeking this relief from the court. We're such good people, she's always telling Judge Lyman. We're so agreeable to everything. We always try our hardest. As set forth in Exhibit A, and regrets the need to involve the court in this matter, but the conduct of counsel for the Wayfarer defendants have left them with no other choice. Ms. Lively asked the court to enter an order holding that Ms. Lively, as the plaintiff, is entitled to be the first examiner in all depositions that are duly noticed as trial testimony. As plaintiff, Ms. Lively has the right to present her case in chief first. So she's really worried about getting into this guy first. Many of these depositions, including that of Mr. Greenstein, to be conducted in California, likely will serve as trial testimony pursuant to Rule 32A4B of the Federal Rules of Civil Procedure, which seems to state at a hearing or trial, all or part of a deposition may be used against a party on these conditions. A party may use for any purpose the deposition of a witness, whether or not a party, if the court finds, in brackets, it risks creating jury confusion to have the Wayfarer defendants begin questioning for testimony that Ms. Lively likely will present as part of her case in chief. For example, the order of questioning of a witness would materially influence how the jury perceives that witness. If the jury first hears video excerpts of Ms. Lively's counsel asking questions that reference earlier questions posed by counsel for the Wayfarer defendants, they will lack foundation to properly contextualize that testimony. So again, your regular average person on the street, just like your regular average content creator, cannot make up their own minds without being firmly steered in the right direction. And we all know the right direction is Blake Lively's direction. So again, the saying, these people cannot understand my point of view. If Ms. Lively's counsel then plays the Wayfarer defendants' original questions to establish that missing foundation, those foundational questions will have already been framed by the Wayfarer defendants. And that's not fair because she needs to frame them first, further distorting the jury's perception of that witness. The court should exercise its authority to control the ordering of witness examination to ensure fairness and create an effective mechanism for the determination of the truth. Scheduling one deposition before another where such priority will likely clarify the factual issues and streamline further discovery in this case. That was case law cited there, Oakley versus MSG Networks. The Wayfarer defendants' position that they are entitled to be the first to question simply because they were the first to notice certain depositions is contrary to law. While it was once well settled that priority in depositions went to the party first serving a notice of examination, absent compelling reasons to the contrary, that rule was abolished in 1970 with the promulgation of Federal Rule of Civil Procedure 26D to make clear and explicit the court's power to establish priority by an order issued in a particular case. So basically, it could go either way, but she just feels that it should be her way because it suits her narrative, her way of steering it. It's not going to look good for her if it goes the other way in court. for the reasons, sorry, I'm clearly cross this morning. Do you know what? I'm getting to the point where I'm kind of objecting to doing this in my own head because I'm getting really far into A Course in Miracles now, and I've had some road bumps in my life this year where I've fallen into old patterns, and they're really clear now in my mind what my drawbacks have been in the past and what I need to watch about myself in future. And everything to do with A Course in Miracles makes a lot more sense to me now, and I kind of know my path. So actually to be doing this at this point to myself is really anti everything I feel like I should be doing. So I might be one of the few people out there that's really ready for this to be over. But anyway, for the reasons explained herein, Ms. Lively respectfully requests the court order the deposition of Mr. Greenstein to begin at 8 a.m. PST sharp, meaning testimony commences at that time, and enter an order holding that plaintiff shall be the first to question Mr. Greenstein and shall have 4 hours to question him, including 30 minutes of breaks if requested. So here we go. Ms. Lively's counsel has made good faith efforts to meet and confer with the Wayfarer Defendants Counsel in accordance with this court's individual practices, as illustrated in the attached email, which I think might be sealed. Opposing counsel conveys various factual assertions and casts unfounded and irrelevant aspersions on Ms. Lively and her counsel in the conferral correspondence that are demonstrably false. Oh dear. So anyway, let's move on to this request by Ellen Garofalo for a judgment on the pleadings. So this is basically the second amended complaint that you're looking at. So Ellen is looking for a judgment on these specifically. So the ones that are highlighted, so not touching the first cause of action, which is SH in violation of Title 7. So they're going for dismissal or a ruling on these, basically. Second cause of action, retaliation in violation of Title 7. The third cause of action, SH in violation of Federal Employment and Housing Act. I always want to say association. Fourth cause of action, retaliation in violation of FEHA. Fifth cause of action, retaliation in violation of the California Labor Code. Sixth cause of action, failure to investigate, prevent, and or remedy harassment in violation of FEHA. Against it ends with us moving LLC and Wayfarer, and this is where it's important. All along we've all had, it's bugged us, this fact of we've never seen the contract. We don't know if it was signed. It was Blake L that had the contract, that contracted her out to it. Ends with us move it LLC. Is all of the wording correct? This has been bugging us all along, and this is where it comes into play, where it's finally being tackled in a conclusive kind of way. So, oh, that's funny now. There's the seventh one pitched in there. I'm sure somewhere in this document it says the seventh cause of action isn't mentioned in the second amended complaint, but if you look at it, it's there. So maybe they didn't spot that Wayfarer's side. There's something in the other document when we get to it, I'm sure it says as if the seventh cause of action is missed out, but it's actually there. It's just not being made a separate paragraph. So that might be an issue in itself. So anyway, because they're I don't know if they refer to seven. So the seventh cause of action is aiding and abetting harassment and retaliation in violation of the FEHA against Nathan Tagg, Abel Wallace, and street relations. I think they will cover that, I think, just off the top of my head from what I've read through. But I think they thought that it wasn't mentioned in the second amended complaint from what I've read in that. Anyway, so then it jumps to the 12th cause of action, false light invasion of privacy against Wayfarer, Baldoni, Heath, Sarowitz, Nathan, blah, blah. 13th cause of action, SH in violation of California Civil Code against Baldoni and Heath. 14th cause of action, defamation per se against Wayfarer, Baldoni and Heath. And the 15th cause of action, civil conspiracy against all defendants. So let's jump to the document. So I'm sure some of you will have gone through it with other people. So I'm going to try and whiz through it relatively fast and not read all of it. So Ellen, these are the main points that Ellen has picked out that she's addressing. So FEHA does not have extraterritorial application, as we got through the other day. A big part of this is going to be determined whether some of the things that Blake has cited, because in the language of them, they contain no description of how they would be extraterritorially applied. It's like, if it doesn't exist, if it's not being specified how it would work, you can't have it, basically, is Wayfarer's argument. So thus plaintiff's FEHA claims, third, fourth, sixth, seventh, to mention seventh there, seventh causes of action should be dismissed with prejudice. Plaintiff's claims for violations of other California statutes, including California Labor Code, fifth cause of action, and California Civil Code, 13th cause of action, fail for the same reason. Let me just see if I can find, I'm sure I saw a bit where it said over that seventh thing, unless I'm going mad and getting hallucinatory. Let me just scroll through that quickly. These are all table contents. Maybe it comes up later. I'm sure I've read it somewhere. Maybe it was in one of the separate bits of paper where they do the declaration. Maybe it was on that. Right, let me get back to where I was. So Lively fails to allege an adverse employment action, a requisite for retaliation claims under FEHA, fourth cause of action, and Title VII, second cause of action. Lively fails to plead a causal link between her complaints of harassment and the alleged smear campaign as required for retaliation claims under FEHA and Title VII. Specifically, Lively fails to plead temporal proximity, I think that should say, between the alleged protective activity and the commencement of the alleged smear campaign or a retaliatory purpose. So here it says the SAC does not include a 10th or 11th cause of action, but skips from the 9th cause of action to the 12th cause of action. The table of contents omits, I knew I was right. The table of contents omits the 7th cause of action for aiding and abetting FEHA. It doesn't. They just didn't put it properly in a paragraph. Do you know, I always pat myself on the back when I actually managed to spot something. I'm so pleased with myself. Do you know, I'm easily pleased. I'm such an easily pleased person. So Lively fails to allege that she exhausted her administrative remedies against It Ends With Us Movie LLC, a predicate for any FEHA claim against It Ends With Us movie. Lively's defamation claims, 12th and 14th causes of action, are barred by California's litigation privilege or New York's fair report privilege, whichever law applies, and Lively fails to plead a civil conspiracy, specifically a tort that all defendants were capable of committing at the same time, in the same place, in the same way. 15th cause of action. So here we go. I'm going to just kind of mostly just dive into where I've highlighted. So filming began in early May 2023. So literally almost immediately Blake cried SH, didn't she? So It Ends With Us movie and Lively, through her company Blake Inc., entered into an actors loan out agreement with It Ends With Us movie for Lively's acting services. Wayfarer is not a party to the actors agreement, which provides whatever that says there, blanked out. So as many people have kept noticing to the judge, Charles Babcock included, when he pulled Blake on in her deposition, where was anything shot in California? You know what I mean? He was really clear about where filming was shot with her, wasn't he? Getting her to clarify. So the film was shot in New Jersey and New York, where Lively resides. Lively first complained about behaviour in May 2023. On May 26, Lively told Sony that she wanted to file an HR complaint. So filming was suspended in mid-June 2023 due to those writers' strikes and Screen Actors Guild. So during that time, so the start of filming to June 14, 2023, Lively experienced invasive, unwelcome, unprofessional, and sexually inappropriate behaviour. So on November 9th, Lively presented a list of 17 protections for return to production as a condition of her return to complete the film. The 17-point list was intended by Lively to remedy the misconduct that Ms. Lively and others had reported earlier that year. So just bear in mind that everything in inverted commas, is just literally pulled from the second amended complaint. They're not admitting to anything in here. So as we know, they agreed to Lively's terms just to get back on board with the filming. On January 19th, 2024, the parties executed a contractual rider incorporating those terms into the unsigned May 2023 Actors Agreement. Wayfarer was not a signatory to the November 2023 rider, which was signed by It Ends With Us Movie only. November 2023. That right now? Am I getting mixed up? Oh, I'm getting all backwards in my head. Why would it be 2023? Is that right? Am I getting totally mixed up now? I'll keep going. On January 4th, 2024, the parties it must be. Yeah, must be. I'm just getting so mixed. It's been going on so long. I'm getting totally mixed up with the years at this point. On January 4th, 2024, the parties participated in an all-hands meeting in New York where, according to Lively, the plan was approved for implementation of all these protections. And again, what bothers me about this, about the Blake Lively thing, and again, it's a narcissistic type thing, is this idea that she took responsibility for all of the employees, all the cast, and all the crew moving forward. Who out of all those people went to her and said, Blake, will you please represent me in this? I want to be represented by you. I want to come under your protective umbrella. No, Ms. Lively feels that only she can be responsible for everybody on that set. I mean, that's a power move in itself, isn't it? It's saying only she can dictate what is a safe set, a safe environment. She wants control of literally everybody on that set, doesn't she? So production resumed on January 5th, 2024 and concluded on February 9th, 2024. It hardly seems to have filmed at all. It doesn't, like some films just seem to take forever to film whenever it talks in terms of literally the amount of time that was actually spent on set. When you think of Isabella, that was only on the set for 4 days and such, filming's hardly taken any time at all. So the whole thing would have taken an awful lot shorter time had Blake not been trampled. Can you imagine how short this period would have been if she hadn't have caused all of the issues? So neither the SAC nor its forerunners identify any act of harassment that occurred in the second phase of filming, January 5th to February 9th, 2024. In fact, on January 14th, 2024, Lively assured a cast member that the inappropriate behaviour had been stopped and that it's a professional set and we're getting good work. So on the eve of the film's premiere and release, rumours of discord on the set already swirling in the press. Accordingly, on July 31st, the Wayfarer parties contacted a crisis communication specialist to diffuse the negative publicity and protect his reputation as the film's director. On August 2nd, 2024, the crisis management team circulated a scenario planning document with a proposed strategy should Lively and her team make her grievances public. Lively contends that this was the launch of a smear campaign, and obviously she thinks it went well on into forever and ever and ending and always, and it was well financed by multi-billionaire Steve Sarowitz to bury and destroy anyone that challenged Mr. Baldoni's brand. Based on these allegations, Lively asserts claims of SH and retaliation under California and federal law, breach of contract, civil conspiracy, defamation per se, and false light. So this is talking about the standard for a judgment on the pleadings that they've requested. Rule 12C permits a party to move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. The standard for a Rule 12C motion is the same as that for a Rule 12B6 motion to dismiss for failure to state a claim. So that's kind of why Justin's got bounced, isn't it? So a complaint must offer more than labels and conclusions, a formulaic recitation of the elements of a cause of action, or naked assertions devoid of further factual enhancement in order to survive dismissal. The plausibility requirement calls for enough fact to raise a reasonable expectation that discovery will reveal evidence supporting the claim. And I think we're seeing that she's struggling to get discovery that will, I know, like, obviously Wayfarer biased at this point, but the mere fact that she still needs more signal messages and more signal messages, and everything that she's received does not bolster her claim. So she needs more, and she needs more, and she needs more. She's not getting the fact that it just doesn't exist, that actually the stuff that they've withheld was actually trying to save her some time because it wasn't of any value to her case. It just literally was nothing. I'd have been the same over those messages the other day that were about the launch of the website, that were just all that back and forwards nonsense over can you open it, can you see it, can your wife's phone see it, how is it displaying on this device? If I had all of that in my position, I wouldn't give it to the plaintiffs either, because I'd think, what a load of nonsense, they don't need all that gumph. That'd be my perspective on it. I'd be no good as a defendant in a legal case, clearly, because I'd be doing the work for them, because I'd be going, oh, you don't need that, there's nothing criminal on that. So a claim has facial plausibility where the plaintiff pleads factual content sufficient for the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. So let's skirt down a bit. So regarding this Federal Employment and Housing Act, I always have to be very careful with myself and the extraterritorial application of it. The threshold question is whether FEHA or the other cited California statutes have extraterritorial application where, as here, the plaintiff is not a California resident and the discriminatory conduct did not occur in California. I mean, just reading it like that, it's like, how does it make sense, this lawsuit, just from the perspective of that? It'd be like me trying to fight something in France using UK law or something, you know what I mean? So failure to adequately plead grounds for extraterritorial application of state law constitutes a failure to state a claim on the merits. FEHA does not protect non-California residents such as Lively, where the allegedly discriminatory conduct occurs outside California. California legislature did not intend a statute to be operative with respect to occurrences outside the state unless such intention is clearly expressed or reasonably to be inferred from the language of the act or from its purpose, subject matter, or history. So then we've got case law cited whereby when a statute gives no clear indication of an extraterritorial application, it has none. So it is reiterating some of the arguments it made from the other day in its claims, Wayfarer. So we'll just skirt down a bit because we don't need all of that necessarily. So the employee or employer's residency is not sufficient to overcome the presumption that FEHA does not apply when the tortious conduct is outside of California. So it don't matter that Wayfarer basically is based in California. That's not sufficient, to make California laws or FEHA and the whatever code it is, the Labour Code, to apply, basically. To apply California law, the complaint must establish a substantial connection between the situs of the legally relevant conduct to California. To determine whether there is a substantial connection, courts look to the location of where the core of the alleged wrongful conduct occurred, which we know is nowhere near California. Although the actors' agreement calls for the application of California law, a contractual choice of law provision does not overcome the California statute's lack of territorial reach. The alleged acts of SH occurred during the first phase of production on the New Jersey set and in New York. Thus, the allegedly hostile work environment, which the core of the alleged wrongful conduct, was not in California, but in New York and New Jersey. So we've got some case law cited there whereby if California-based employees participated in or ratified the alleged tortious conduct, the complaint must so state with specificity. Right. So plaintiff alleges that Wayfarer's principals Jamie Heath, Wayfarer's president, and Justin Baldoni, who would have authority to ratify an employee's conduct, were in New York during the filming, where they allegedly committed the acts of harassment that are the subject of the complaint. Steve Sarowitz described that's what I say. Multi-billionaire automatically pops into my mind. As I said the other day, this is how you instantly know this is a Wayfarer document because it doesn't state multi-billionaire. Steve Sarowitz, described as a Wayfarer founder and financial backer, is a resident of Highland Park, Illinois. The complaint is bereft of any allegation that Sarowitz participated in or ratified any discriminatory conduct or adverse employment action, much less in California. So in short, FEHA has no extraterritorial application. Plaintiffs claim for retaliation under California Labor Code 1102.5 against Wayfarer, and it ends with us movie fares no better. So I think we can skip some of that. The court must evaluate whether the alleged conduct giving rise to liability, that is, the action that created the litigation, occurred in California. As explained above, all the allegedly harassing conduct occurred in New York or New Jersey during the first phase of filming, and thus Section 1102.5 does not apply. Finally, Lively alleges that Baldoni and Heath violated California Civil Code 51.9, which prohibits SH by any person in a professional relationship with the plaintiff, specifically including directors and producers. So, unlike its other statutes, it's got the problem of the extraterritorial application. There's no specificity of how it would work out of state. In sum, the lack of extraterritorial application cannot be cured by amendment. Therefore, plaintiffs' claims under FEHA California Labor Code 1102.5 and the Civil Code 51.9 should be dismissed with prejudice. So the Title 7 and the FEHA claims against it ends with us movie fail, because plaintiff does not plead that she exhausted her administrative remedies. So this is where kind of she was challenging the wrong entity about it, isn't it? That she bypassed. It ends with us movie, in essence, as an LLC. So FEHA, assuming that it applies out of state, requires that an employee such as plaintiff exhaust her administrative remedies before filing a civil action alleging FEHA violations. Similarly, to assert a claim under Title 7, a plaintiff may, bring a suit in federal court only if she has filed a timely complaint and obtained a right to sue letter. So this is going back to this idea that many people said, and makes a lot of sense, that when she lodged, a lot of people said at the time that it was incorrectly filed, basically, the California Civil Code, the CRD, because the wrong people are mentioned on it, like Jed Wallace got mentioned on it. She's gone after Wayfarer rather than it ends with us movie, and this is the problem. So let's read the footnote. So I don't think, so Section 51.9 that she's trying to invoke was intended to fill a gap in FEHA by extending harassment claims to those in professional relationships with the plaintiff. Lively alleges harassment in the workplace on the set of the film. So the two things that she's trying to apply, they conflict each other, basically. I think that's what it's trying to say there. She's trying to exert it as workplace and professional relationship with the plaintiff at the same time. So I think there's a confliction there, is what that's trying to say, that she's one thing displaces the other, and she's trying to use both, I think, is what that's saying. So exhaustion includes the timely filing of administrative complaints addressing the claims and parties at issue, as well as the procurement of right to sue letters. So say she got that right to sue letter from the CRD, it had the wrong name on it, basically. It had the wrong company on it. Plaintiff has the burden to plead timely exhaustion of administrative remedies, such as filing a sufficient complaint with the California Civil Rights Department and obtaining a right to sue letter. Under FEHA, exhaustion of administrative remedies is a jurisdictional prerequisite to resort to the court. Therefore, failure to file an administrative charge before commencing suit is ground for dismissal of an action for violation of the FEHA. And don't forget, she also turned down, didn't she, whatever, can't think of the name that it's called, but there's an investigation tied to filing a CRD, isn't there, that you're offered an investigation as part of it, and she turned that down. Similarly, under Title VII, failure to exhaust administrative remedies is grounds for dismissal. On December 20th, 2024, Lively filed complaint with the California Civil Rights Department against Wayfarer and 10 other defendants and received a right to sue letter for the named parties. It ends with us moving. Lively's employer and party to Lively's actor agreement and rider is not identified in Lively's CRD complaint, and as a result, Lively did not obtain a right to sue letter with respect to It Ends With Us movie. Accordingly, It Ends With Us movie is entitled to dismissal of Lively's 3rd, 4th, 6th, and 7th causes of action. In addition, as more than 300 days have elapsed since the allegedly unlawful employment practice, It Ends With Us movie is entitled to dismissal with prejudice of Lively's 1st and 2nd causes of action. So the SAC fails to plead an adverse employment action within the scope of FEHA or Title VII. So to establish a prima facie case of retaliation under Title VII, a plaintiff must show, 1, that she engaged in a protected activity, 2, the employer was aware of the activity, 3, the employer took a materially adverse employment action against her, and 4, a causal connection between the alleged adverse employment action and the protective activity. So FEHA similarly provides that it is unlawful for an employer to discharge, expel, or otherwise discriminate against any person for complaining of SH or other discriminatory conduct in the workplace. And there's some little explanation here of retaliation is a bit broader under Title VII than under FEHA. So the employer alone is liable for retaliation under FEHA. The plaintiff attempts to blur the lines between Wayfarer and It Ends With Us movie, who is the party to Lively's loan-out agreement and Lively's employer. As noted, Wayfarer is not a party to the loan-out agreement for Lively's acting services or the rider. It really was done with not enough thought whatsoever. That CRD was filed in order to just hand to the New York Times, basically. It wasn't meant to make sense, really. It wasn't given that much thought. That's the problem. She never intended to sue Justin Baldoni. She just expected to file that CRD and completely shut him up and completely walk all over him. But she didn't realise she'd done that thing of just pushing too far. Even a good person, there's a saying, isn't there? What is it? It's that never push a good person too far to the point where they just don't give a fuck or something like that, isn't it? It's something like that. It's a really good saying. And I'm a bit like that. And people will say this about Capricorns, you can hurt us and hurt us and hurt us and hurt us, but we get to a point where we go, right, that's it, you're gone. And we can shut off like that. And it's like, you're dead and gone, it doesn't matter. You know what I mean? And this is what they've done to Justin in effect. They pushed and pushed and pushed and pushed and got and got and got and got. But they made the mistake of going one step too far. And it's like, you launch an SH allegation against me, I have no option but to like come down on you like a ton of bricks. And the whole thing, the whole problem here is that Blake Lively has brought all of this on herself and she just does not get it. So let's just check I've not missed anything there. Let me see if I can make it make sense when I start up again. So not all adverse employment actions violate Title VII or FEHA, and it is important to separate significant from trivial harms. The plaintiff must show the employer's retaliatory actions had a detrimental and substantial effect on the plaintiff's employment. So let me just go back there. Yeah, I think we're fine. So there's some case law cited there whereby plaintiff sustains an adverse employment action only if he or she endures a materially adverse change in the terms and conditions of employment. And as she said herself, when she went back to work after the break, oh, this is a lovely set. It's so professional. So it didn't get worse, did it? So examples of materially adverse changes include termination of employment, a demotion evidenced by a decrease in wage or salary, a less distinguished title, a material loss of benefits, significantly diminished material responsibilities, or other indices unique to a particular situation. Lively does not allege that she was terminated, demoted, deprived of any benefit of her employment, which ends with us movie, assert any act that may have blocked or interfered with a potential employment opportunity or any materially adverse change to the terms of her employment. And in fact, when you think of how she was marketing her brands all over the promo, this has been a problem all along. How can she say that she's suffered anything? Even emotional distress would be very, very tough to provide, and is absolutely why she didn't want to provide her medical records. So the SAC includes only 3 cursory references to adverse employment action, each alleging a coordinated campaign to cast Ms. Lively in a false light during the publicity and promotion of the film and thereafter. So it's based solely on the publication of negative publicity commencing in August 2024 after production ended and after discord on the set spilled into the public eye. So we've got some blanked out redactions here. So it's something from the CRD. So then it goes, by creating a new standard for adverse employment action. So it's kind of saying, if you want to go ahead with this, judge, it's saying you actually have to create a new standard for adverse employment actions for it actually to hold water, basically. So it's almost like the whole giving her treble damages thing, isn't it? You have to be the one that's setting the precedent. If you want to go ahead with this, you have to be the first person to do it, judge, isn't it? Plaintiff's failure to allege an adverse employment action alone defeats plaintiff's ability to establish a prima facie Title VII or FEHA violation sufficient to survive a motion to dismiss. So there was no hardship that happened to her. So the SAC demonstrates quite the opposite. After voicing her complaints, Lively was ceded more control over the editing, not called for in her acting contract, and marketing, and ultimately obtaining an executive producer credit. Was she not just a producer, I thought, in the end? One might even say that Lively was rewarded after her complaints of inappropriate behaviour on the set. I thought she ended up being a flat-out producer, the whole shaboodle. I thought that was the thing. Isn't that why how she got the PGA and that? But it's like sometimes these lawyers are on it, and they wear more on it, even if we don't know what we're talking about half the time. So a plaintiff must plausibly allege that the retaliation was a but-for cause of the employer's adverse action. So it really has to prove that if this didn't happen, X wouldn't have happened, basically. So there has to be this temporal proximity to it, this time-sensitive element to it. So but-for causation does not require proof that retaliation was the only cause of the employer's action, but only that the adverse action would not have occurred in the absence of the retaliatory motive. So they really have to prove that whatever the bad result was, that it was a direct result of the retaliatory thing that allegedly happened, basically. So Lively alleges protected activity, which were the complaints of SH. So there should have been no comeback from that in her eyes. That's what they call protected activity, something that I guess can't be legally retaliated against. So the protected activity, her complaints of SH, and a public relations campaign which commenced in early August 2024 at or about the time of the film's August 6th premiere, that's the alleged adverse employment action. The complaint, however, does not link the two, much less plead that the PR campaign would not have occurred absent a retaliatory motive. Simply put, Lively fails to plead causation. There's no proof that all that all the stuff that was going on in social media at the time of the premiere, there's no causal link, there's no connection to her complaints of SH. So a causal link may be shown by pleading. So let's not read all of that. So a retaliatory purpose can be shown directly or indirectly by timing, where the protected activity was followed closely in time by adverse employment action. So it's this idea of the temporal proximity. It has to look, there has to be a clear causation, a clear like cause and effect, if you like. So over a year passed between plaintiff's May 2023 complaints and the August 2024 launch of defendants' alleged smear campaign. So in Grauer versus UBS Financial Services Inc., an alleged smear campaign was launched more than 4 months after the plaintiff engaged a lawyer and more than 3 months after he resigned, was insufficient to show retaliation. So there's lots of case law cited here whereby it discusses where things like 3 months and 4 months lapse between whatever complaint went in and the alleged retaliation, that three and 4 months is considered exceeding the time limit in a way. A gap of more than several months is typically too long by itself to survive summary judgment. The weight of authority supports the view that 10 or 12 months is too long. Right, so Lively surfaced her grievances in May 2023. The alleged smear campaign. I mean, the thing is, I think this is what it highlights. Filming within days, she was claiming SH on this set. She didn't give it chance to see, is this just a difference in personality? Is it just that I'm not understanding this person? There was no question in her mind about what allegedly. It's like she made a very fast determination, didn't she? Or did she make it, was it a retroactive determination? You know what I mean? Because for most women, the first time it happens, rightly or wrongly, we tend to think, oh, that was a bit odd. I'm just going to see what goes on. You don't just initially go SH in your head. We women are kind of conditioned, aren't we, to kind of take a fair bit of gauging before we determine what something is really. Rightly or wrongly, it's how we work. To me, it's like she very quickly, didn't she, made a determination that this is what it was. But did she call it SH right off the bat? Or did she retroactively call it SH? So Lively surfaced her grievances in May 2023 and the alleged smear campaign began in August 2024, 15 months later. Even assuming that the all-hands meeting in January, where Lively renewed her complaints, is the starting point, there is a 7-month temporal gap between her complaints and the commencement of the so-called smear campaign. And as we've said before, if you're going to start a smear campaign, you don't do it more or less on the date of the premiere of the movie where your money is living, basically, do you? The crisis management public relations campaign designed to counter the already negative and escalating publicity spurred by Lively would have occurred and did occur in the absence of the retaliatory motive. So the SAC includes 2 cursory allegations of retaliatory intent, that the public relations plan was embarked in retaliation for Ms. Lively exercising her legally protected right to speak up about misconduct on the set, and Ms. Abel, Ms. Nathan, Wallison Street, and others employed or engaged by TAG perpetrated a retaliation scheme against Lively in collusion with the Wayfarer parties. It's insufficient to show a retaliatory animus or purpose. In fact, the SAC's own allegations show something entirely different, that the alleged smear campaign was not retaliatory, but an effort to defend Baldoni and Wayfarer against the anticipated storm of negative publicity from Lively and her team's blistering criticism of Baldoni and his work as the film's director to coincide with the film's release. Because if you remember, it was widely being said at that time that Blake had to do this and Blake had to do that because he was doing this and he was doing that and he was doing all of this from the male gaze. And how could he, as a male, direct like a love scene involving a woman? It's that she had to do this. Ryan had to step in and do XYZ. It was all going tits up, wasn't it? That was the message that was being put out there. So about the text messages, these messages do not evidence a retaliatory purpose. They confirm that beginning in late July 2024, after the completion of production and after the end of Lively's acting services, so her contract, Baldoni and the other Wayfarer parties consulted public relations and crisis management to plan how to counter an anticipated onslaught of negative publicity by Lively about a feud on the Ends With Us movie set and the struggle over control of the production, editing and marketing of the film. Ms. Lively's husband had blocked Baldoni on social media, stating we should have a plan for if she does the same when the movie comes out. So it was all about protection. They were worried about the optics of it all, what it was going to do to the finances. It would be helpful to arm us in the case we need to refute any of the claims. So none of it was on the attack. Abel briefed press on the situation and stated to Wayfarer they were armed and ready to take this story of Blake weaponizing feminism. And all of this, she might not like it, but it doesn't mean it's not true. She was weaponizing feminism. It's not anything that wasn't true. They weren't making it up. So we should be prepared should Ms. Lively and her team make her grievances public. Heath stating that's the most important part of this is how quickly they can shut things down and place stories in your favour. So not against her, but just in your favour. Text from Abel to Nathan regarding reckless thoughts of wanting to plant pieces this week of how horrible Blake is to work with, just to get ahead of it. She's putting us through hell. It's not untrue. Text from Nathan, this will be for creation of social fan engagement to go back and forth with any negative accounts, helping to change narrative and stay on track. I did this myself a while ago. I don't know if I told you. Somebody was saying, just on some random something somewhere, somebody were being pro-Blake, reckoning they'd read all the things. And so I just felt moved on this particular day to challenge it and actually just, because I had the information off the top of my head about a document. And it quickly became clear she wasn't actually reading the filings. She was just reading what a newspaper article had said about the filings. And this is what this would have been about, was referring to, and engaging any accounts that are saying this, this, and this without being fully informed. And actually just saying, actually, this is more correct. So Abel inquiring about the cost of social media mitigation and proactive fan posting to counter the narrative surrounding Baldoni, planning for suppressing of negative content about Mr. Baldoni, and the amplifying of negative content about Ms. Lively. And I don't think you can get done. None of it was creating it. They might have amplified it, or they might have considered amplifying it more accurately, but it doesn't mean if he not creating it, I don't think you can legally be done for it. The defendant's concerns proved prescient when on the eve of the August 6th premiere, Lively sidelined Baldoni, instructed cast and crew members to defriend him on social media, and refused to be seen or photographed with Baldoni at the premiere, where Baldoni and his family were banished to the basement until Lively finished her pre-show appearances. The public furore, Baldoni's distress over efforts to cancel him, and Wayfarer's goal to flip the narrative and repair Baldoni's reputation are reflected in the text messages cited in the second amended complaint. Text from Abel that we can't have fans starting to guess why JB is left out of this stuff. by helping to change narrative. Text from Nathan that the worst is over and that Mr. Baldoni likely would not be cancelled. Concern that over threads beginning to appear on Reddit speculating about the feud between Ms. Lively and Mr. Baldoni in connection with allegations of competing cuts of the film. Text from Nathan stating that Lively fucked herself by doing the unfollow thing and insisting on no photos together. Text messages that consisted of drafts of a story outlining Ms. Lively's role in making final cuts to the film. Article addressed Lively's making final cuts to film. Baldoni stating on August 15th that because of the negative articles, there is no way we could just let this go. He was forced into it. Thus, what Lively characterises as a smear campaign began the week of the premiere and was conceived and executed to counter the onslaught of negative press spawned by Lively and her team, quell speculation about an alleged rift between Baldoni and his cast and crew, and explain Baldoni's noticeable absence from joint press events and the lack of group photos at the premiere. Plaintiff, in fact, admits that the plan was not conceived to respond to any particular allegation. It was entirely about managing the public perception that Mr. Baldoni feared might follow the theoretical possibility that Ms. Lively might decide to unfollow his social media accounts. Remember, in a deposition, Blake couldn't point to one article that really bothered her, that really highlighted that it was a smear campaign. There was not one article that she'd seen that bothered her, and she claimed that she wasn't looking at social media about herself, so she couldn't say what was the problem, basically. No reasonable employee should expect that the employer defendant would simply surrender in the face of litigation. Planning to counter potentially negative publicity and efforts to defend one's reputation in the face of highly public criticism is not tantamount to a retaliatory adverse employment action, and plaintiff fails to plausibly plead the requisite causal link. Lively may not like the public criticism she unleashed, but the SAC is devoid of facts that might show that these efforts to neutralise negative publicity had a retaliatory purpose. Absent a sufficient factual basis, the SAC's conclusory allegations of retaliation failed to establish a prima facie, showing that the Lively's sexual harassment complaint were the but-for cause of the smear campaign, as required to plead violations of Title VII or Federal Employment Housing Act. So yeah, she can't really say that she had, because nobody knew about the SH, did they, at the time that the so-called smear campaign was going on? The two are completely separate. So the SAC fails to state claims for defamation per se and false light under California law. Defamation requires a publication that is false, defamatory, unprivileged, and has a tendency to injure or cause special damage. Plaintiff identifies 5 post-litigation statements by the Wayfarer party's lawyer as defamatory per se. Each refutes express allegations in Lively's complaint. Lively was asserting serious and categorically false accusations against Mr. Baldoni, Wayfarer, and its representatives. Lively made false allegations of a smear campaign. Lively's claims are completely false. There was no sexual harassment, and Lively has stated false allegations of sexual harassment. Said it twice now. The SAC cynically fails to note the timing of the allegedly defamatory statements. However, since the statements address the allegations in the complaint, there can be no dispute that they were made after Lively filed her claims in the course of litigation. California's litigation privilege, Civil Code 47B, creates an absolute bar to any defamation claim based on statements made in connection with a judicial proceeding. Section 47B applies to any communication, 1, made in judicial or quasi-judicial proceedings, 2, by litigants or other participants authorised by law, 3, to achieve the objects of the litigation, and 4, that have some connection or logical relation to the action. The privilege of Brian being able to speak out is absolute and applies to all publications, irrespective of their maliciousness. Absolute litigation privilege, not limited to statements made during a trial or other proceedings, but may extend to steps taken prior thereto or afterwards. There's case law cited there to that effect, basically. And more case law here, it protects publications made outside the courtroom and all torts except malicious prosecution. Undergirding the immunity conferred by Section 47B is the broadly applicable policy of assuring litigants, the utmost freedom of access to the courts to secure and defend their rights. It's just all harking back to this thing of the core of the thing, as I've said before, might be being boring, is the fact somebody told Blake Lively that if she filed that CRD, he wouldn't be able to do anything, say anything. She would have the last word, line drawn under it. He'd be like dead in the dirt. She'd be venerated as this, survivor and lover of women and girls and all of the rest of it. Somebody told Blake Lively that would, and you know what I think? I think that there's a good chance that if she loses or this gets bounced out, that you're going to see Blake Lively sue her attorneys because she cannot be seen to lose. So if she loses, it's going to be the attorney's fault because she's always right. So if she lost, if she is deemed to be the loser, it has to be because somebody else gave her bad advice. So my bet right now is that if she loses, you can see her sue her attorneys. That is my thinking right now. So it is desirable to create an absolute privilege, not because we desire to protect the shady practitioner, but because we do not want the honest one to have to be concerned with subsequent derivative actions. California's litigation privilege recognizes that a plaintiff cannot, on the one hand, make accusations in a court-filed pleading, and then, on the other hand, use defamation law to silence any opposition. You can't just say somebody does not have the right to defend themselves. So plaintiffs' defamation per se and false light claims should be dismissed with prejudice. Further, the litigation privilege extends to torts except malicious prosecution, and therefore Lively's claims based on the alleged smear campaign, including retaliation under the FEHA and Title VII, and civil conspiracy, which are based solely on the alleged smear campaign, are absolutely privileged. Brian's comments are privileged and for this reason should be dismissed with prejudice. New York does not recognize a common law false light invasion of privacy tort. The allegedly defamatory statements are absolutely privileged under New York law. In contrast to California, New York's litigation privilege does not extend to out-of-court statements. So the little footnote here, the allegation that a defense lawyer's denial of claims against his or her clients is defamatory per se is antithetical to the First Amendment and a lawyer's ethical obligation to defend his or her clients, even in public statements in highly publicized action. So let's just scroll this up a bit. However, New York Civil Rights Law 74 creates the fair report privilege, which provides absolute immunity from civil liability for defamation. Importantly, Section 74 protects reporting on allegations made in official proceedings, regardless of whether the underlying allegations are true or false. So it doesn't even really matter. To invoke the 74 privilege properly, defendants need not prove that the statements made at the proceeding were themselves accurate. Rather, all that matters for the application of 74 is that the article is a substantially accurate rendering of what was said, even if the testimony given was not true. There is no obligation for a report to tell all sides of the story to be substantially accurate. These statements by counsel, to the extent that they can even be construed as defamatory, which they are not, merely repeat defendants' assertions made in court and fall within the scope of protected speech under Section 74. Counsel's other statements concerning plaintiff's motives for making her claims are statements of opinion and not subject to a claim of defamation. New York also protects statements of opinion from claims of defamation. So Condit versus Dunn is cited there, whereby New York law grants opinions greater protection from defamation actions than does California law. So when the defendant's statements read in context are readily understood as conjecture, hypothesis, or speculation, this signals to the reader that what is said is opinion and not fact. She really has a problem all along with assuming the general public at large is illiterate and uninformed and can't make up their own decisions, basically. And that is the crux of her argument about all of us in August that started jumping on it, thinking this is weird, that all of us had to have been swayed by someone else because we don't have minds of our own. That is as tracked all across this lawsuit in everything that Blake Lively does. How many times has she called content creators unwitting in what they are putting out there? She's used that numerous times. So statements of rhetorical hyperbole or imaginative expression are not actionable. So like him saying Madison Square Garden and selling tickets and all the rest of it, because they cannot reasonably be interpreted as stating actual facts that could be proved false. So to establish a claim of civil conspiracy, so this is where she fails, because this is part of the problem when she brought Jed into it and kind of accused him backhandedly of SH when he'd never even met her in trying to prove a conspiracy. Yet everybody has to be in on all parts of it, don't they? Everybody has to be acting under the same auspices, basically. You have to be able to prove that. To establish a claim of civil conspiracy under either California or New York law, a plaintiff must plead an underlying tort that the alleged conspirators are capable of committing. Tort liability arising from a conspiracy presupposes that the co-conspirator is legally capable of committing the tort, i.e., that he or she owes a duty to plaintiff recognised by law and is potentially subject to liability for breach of that duty. So she has to be able to prove that everybody, Nathan, Abel, Heath, Jed, whoever, all of the corporations, all had a duty of care to her for every specific element of it. And she's got trouble proving that. So co-conspirator must by legally be, do you know there's a few mistakes in this? She must have been spitting mad when she was doing it. I think she's fed up, isn't she, Ellen? Co-conspirator must be legally capable of committing the underlying tort. I think that should read. A mere conspiracy to commit a tort is never of itself a cause of action. Allegations of conspiracy are permitted only to connect the actions of separate defendants with an otherwise actionable tort, various case law there. So, in the little footnote here, the elements of civil conspiracy are 1, an agreement between 2 or more parties, 2, an overt act in furtherance of the agreement, 3, the party's intentional participation in the furtherance of a plan or purpose, and 4, resulting damage or injury. And she's got a real problem proving damage or injury, hasn't she? So a conspiracy cannot be alleged as a tort separate from the underlying wrong it is organised to achieve. Thus, where the underlying wrongs are privileged, the immunity applies to all conspirators. So her SH claim is the privileged thing, isn't it? And the retaliation. So plaintiff's pleading of a civil conspiracy is less than precise, relying solely on the conclusory allegation that each defendant committed numerous wrongful, unlawful, and tortious acts pursuant to defendant's common plan, design, or agreement. The second amended complaint leaves defendants and the court in the dark as to who conspired with whom to commit what tort. For instance, as only an employer is liable for FEHA retaliation claims, the non-employer defendants, Baldoni, Heath, Sarowitz, Nathan, Abel, Tagg, and Wallace, have no duty not to retaliate, and thus cannot be liable for conspiring to retaliate against Lively. As explained above, plaintiff's claims under FEHA Labour Code and the Civil Code and the Title VII retaliation claims fail, as do plaintiffs and Title VII retaliation claims. She's missed a bit there as well. Defendants cannot conspire to commit torts that are not actionable, nor can defendants have conspired to defame Lively as her underlying claims are privileged. So it's almost biting her in the neck, isn't it? The CRD and it being privileged in a way. The privileged, which immunises the named defendants, also immunizes the alleged co-conspirators. Also, the SAC is bereft of any allegation that Abel, Nathan, Wallace, and Tagg were involved in the production of the film when the alleged harassment occurred on the set. Therefore, they could not, under any stretch of the imagination, be liable for the harassment or retroactively conspiring to harass Lively, because they've got no dog in the game, basically, or no dog in the hunt, or whatever the thing is. They can't retaliate against her for what happened on the set when they had no party to what happened on the set. So finally, Civil Code 51.9 applies only to those in a business or professional relationship with Lively. The SAC does not allege that Nathan, Abel, Tagg, and Wallace had any duty to Lively arising from a professional relationship, and thus these parties cannot be liable for conspiring to violate Section 51.9. These are only a sampling of the shortcomings in plaintiffs' efforts to plausibly plead civil conspiracy against 10 defendants to commit no fewer than 11 torts and 2 breaches of contract. For conclusion, for the foregoing reasons, the defendants respectfully request that the court enter order granting this motion and dismissing the 2nd through 7th and 12th through 15th causes of action with prejudice. So never to come back, basically. So, need a big rest after that one, but I hope that was useful to you, at least to get a slightly different perspective, a slightly different calibration of it all, if you like. But let me know your thoughts and what your feelings are about it. Do you think that Judge Lyman is going to seriously look at this? It's interesting, isn't it? Because I think this is kind of a halfway house between a motion to dismiss and summary judgment, isn't it? This asking for a judgment on the pleadings. Wonder why they decided to go for this rather than waiting for summary judgment, if they just got sick of all the back and forth and all of the negative articles, or, like, because it's been a lot, hasn't it, the last week, between all the Taylor Swift nonsense and how all of that came out as if, like, Justin had told somebody to go jump over Travis Kelce's fence and the rest of it. I mean, half of it I've not even commented on here because I just haven't wanted to propagate it. It's sensationalist, a lot of the stuff that's happening, to my mind, and I don't want to talk about it because I mean, we're all doing our best with this as content creators, but there comes a time sometimes where you think this is just extending the narrative of it all, and I'd rather just keep it a bit more factual and a bit more on what matters and what I still feel about it all. Sorry, I'll stop sharing so you can see me better. What I still feel about it all, I'm very dark today, is that we're supposed to be learning from this. We're supposed to be learning from Ryan and Blake. That was the best case scenario out of all of this nonsense is for us to learn as human beings about what to do and what not to do in life, and to be able to quickly spot a narcissist and move yourself away from them and understand the battles that you can win, that you should fight, to understand about ego and what happens when you live from an ego-minded perspective, when you allow your ego to run away with you, and to watch the kinds of people you hang out with as well. Like when it comes to Taylor Swift, don't sacrifice your soul just to have cool friends, basically. Because we do pick up so much just from those around us. I mean, I've just finished like another period of study, got a new qualification, and one of the things it was saying was about certain studies, where we're so, and it's why hypnotherapy works so well, because we're so easily conditioned, we're so receptive, like these walking receptors walking around. So everybody you come into contact with and why you should protect your energy is everybody that you come into contact with has some bearing on you. It was saying like about a university study where they'd kind of set it up that these students walking down a corridor, and they'd set it up so they had to encounter somebody that would either hand them a cold drink or a hot drink. And when they were later asked to describe that person, they would actually describe them as cool or fan. The person would act the same regardless in the interaction, but they'd either be holding something, ask somebody to hold something cool or something hot, and they were later described as either in terms of being either a warm person or a cold person, just because somebody literally held a cup that the person handed to them. So that, and it's like if you're in a room and somebody's talking about old, frail, retired, having been to Florida, anything to do with age related that seems old or arthritic or aches or pains, you would literally walk out of a room. Tests have proved that you would walk out of a room looking more decrepit, walking slower, seeming more lifeless. That is what we are. So when you hang out with the likes of, your Brendan Sklenar and all that wants to hang out with the Blakes and the Ryans of the world, you are being conditioned by these people and you will start to act like them. The whole point of this case to me, the universal point of this case, is to effing learn what the F you're doing to yourselves basically out there, is to wise up. That's to me what this case is and what we should be learning from. But it is why hypnosis works so wonderfully well for you, is that we are all receptive and we're all out there being negatively programmed all the time. Imagine what would happen if you positively programmed yourself, and that's where hypnosis comes in. And you can always book a free call with me for my actual real work that I'm supposed to be doing. All right, but please do hit that like and subscribe and share if you've enjoyed this at all, and have a lovely weekend. I will see you later.